Started. Good morning and welcome everyone. I'm Zane Dames, the Marketing and Events Manager at Digital. I'm pleased to welcome you to another one of our insightful webinars, From Ideas to Assets, Building Intellectual Property Maturity. As myself and much of the digital team are based in Vancouver, British Columbia, we respectfully acknowledge that we are gathered here on the traditional ancestral territory of the Musqueam, Squamish and Tsleil-Waututh peoples. Please note this webinar is being recorded and will be shared with our audiences in the coming week. If at any point during the session you have a question, please type it into the chat and we'll address them at the end during the Q&A portion. That's it from me, and I'll be handing it over to Jen, our Director of Intellectual Property, to get this webinar started. Thanks, Jen.
Thank you, Zane. Bonjour, everyone, and welcome. It's wonderful to have attendees joining in from across the country for this month's webinar, and our last one before taking a short break over the summer. Whether you're a new or a returning participant to Digital's IP series, we're thrilled that you could join in for this Thought Leadership Power Hour. Next slide, please. Canada is globally recognized for innovations in sectors such as AI, quantum, clean tech, and precision medicine. But this oft doesn't translate into clear commercialization paths for the organizations creating them. Intellectual property, the stage at which an organization has developed a comprehensive strategic approach to managing its IP assets, impacts a company's ability to innovate, to compete, and achieve long-term success. Over these next 60 minutes, we'll explore stages of IP maturity and assessing your organization's IP maturity level, considering policies, processes, and practices to ensure effective creation, protection, and utilization of IP, discussing practices that will help your organization mitigate IP risks, including undertaking freedom to operate analyses, and a Q&A portion to close out. Fundamental to the global innovation clusters is collaborative innovation, setting the framework for projects that address cross-country challenges while creating technology products and services that can scale across industries and ultimately across the world. Digital's IP strategy supports the development, ownership, and retention of Canadian IP through numerous vehicles, and informational sessions with thought leaders like we've today are one example of that. I have the pleasure of introducing today's panelists. Please join me in welcoming Mike McLean and Karima Bawa. Karima is Strategic Advisor on Intellectual Property and Data for the Digital Global Innovation Cluster. Recognized as one of the most influential women in IP industry by World IP Review, she is the co-author of the Intellectual Property Guide, IP Literacy and Strategy Basics, a senior fellow at CG, and board chair at the Intellectual Property Ontario, to name a few of her hats. With extensive expertise on the commercialization of university R&D, capacity building and IP strategy for Canadian innovators, and in strategically developing, managing, and leveraging IP, she also served as former General Counsel and Chief Legal Officer for BlackBerry, as it grew its operations in North America, from North America to 175 plus countries. And Mike, CEO of the Innovation Asset Collective, an organization helping Canadian data-driven clean tech companies maximize the value of their intangible assets to provide leverage for the businesses to scale and to build capacity in the Canadian IP ecosystem. Before joining IAC, Mike was a Senior Vice President of IP Services at Tech Insights, where he founded the Patent Development Service and established a center of excellence around patent portfolio management and patent assessments. His practice enables data-driven decision-making and effective identification of patent assets for enforcement or sale, provides guidance on invention selection and patent acquisition programs, and ensures the alignment of patent portfolios with IP and business strategy. He has worked extensively with the technology practices of major law firms, in-house corporate counsel teams of global tech companies, and external licensing agencies. We're in for a wonderful discussion today. And with that, let's kick it off. Both of you are engaged in various initiatives related to IP across the country. Karima, first off, I'd like to start with you and your role with Digital and some of the IP initiatives that you're involved in.
Thank you, Jen, and thank you for that kind introduction. I have the pleasure of working alongside with you, Jen, obviously, to work with companies and their collaborative initiatives members that are really looking to build out different types of new innovations, new products, new projects. And so I work with you to help companies develop the IP strategies and work out fair, balanced arrangements around licensing and sharing of IP. I also am the chair of IP Ontario, which is an agency that was really developed to achieve a number of different objectives. The principal mandates are helping companies gain a better understanding around intellectual property, providing supports and various services. And then lastly, I also have recently started working with new ventures and helping them around their IP education strategies and courses and programs.
Thank you for that. And Mike, I'm wondering if you can share with us, about IAC and its mandate.
Absolutely, thank you. IAC is a not-for-profit funded as part of the federal IP strategy through ISED. And our mandate is to really address clean tech SMEs in Canada and work to improve their freedom to operate. That is, ensuring their access to international markets is not constrained by other companies' IP positions, and helping address those issues for them. And then working to build the capacity within those businesses with the entrepreneurs and innovators to understand and build IP strategies and to execute on those strategies in effective ways that allow those businesses to grow and compete successfully against international competition. Really, the overall goal of that program is to build a set of IP savvy entrepreneurs here in Canada. And then we also interface out to a lot of the other IP programs that are running at the federal and provincial level. We've established a really strong core of IP expertise within our staff and look to leverage that to the benefit of the broader group of Canadian initiatives.
Yeah, and I'm just going to chime in, Mike. I think one of the most impactful things that IAC does is sort of be that strategic broker, that independent broker who really works. And I've had the good fortune of working with you and many others on your team. And I always say we always appreciate companies being able to stretch that definition of clean tech data driven to avail themselves of the services of IAC.
Well, thanks for that, Karima.
Thank you both. IP is often seen as being synonymous with patents. While IAC was originally designed to be a patent collective, are patents the only form of IP that organizations should be concerned about? Mike, I'll start with you, and then Karima, if you want to jump into the discussion as well.
The short and quick answer is no, but let me elaborate. A core part of the IAC operation is our patent portfolio that we're building to help shield Canadian clean tech companies. We've identified over 125 large multinationals that play in the clean tech space and that have a history of litigating their patents against SMEs around the world. When their market share is threatened, when technology is disrupted, those companies have an extensive history of using IP to their business advantage. So we're trying to build a patent portfolio that our membership companies can access that can help balance that equation, provide assets out to small companies that may not have a self-sufficient IP position of their own and need additional assets in order to access the market to keep from having a significant or punitive royalty rate established on their products or other restrictions placed on how they access the market. So that continues to be a really core part of what we're doing and of the value we deliver to our membership. That being said, feel incredibly strongly that a broader suite of IP rights are really necessary for a business to be successful, in particular in IP-rich industries or technologies. And not the IP density in a given technology can vary quite significantly. So that's a key factor in determining some of the mix of the rights that are needed in a business, is to look at really what is that landscape of rights out there and what type of rights you're going to need to establish your own ownership position around the technologies you're developing. But we really recommend our companies look at creating a lattice of rights, whether that be a mix of patents, trade secrets, copyrights, know-how, layered in a lot of really sound practice with their agreements that they're signing with other organizations. Capturing all of that in ways that support each other ends up with a much stronger position and a much more robust position than if you relied on any individual asset or even asset type.
And I think that the thing that I would build on Mike's comment is really around making sure that your agreements give you, appropriate protections, maybe shield you from lawsuits, make sure that when you're sharing things, you might have some reciprocal rights that are made available to you. So, I mean, sometimes I don't even think people think about their agreements as creating IP rights for themselves. And so that's something that's really important. And then thinking about the different forms of IP and the different types of assets that they apply to, right? Patents can be expensive. They're also geographical in nature, and a lot of companies, even really big companies, can't afford to enter into all of these different markets. And sometimes they lay out a bit of a roadmap for your competitors. So, there are things like that that need to be considered in exploring what kinds of IP rights are important for you. But, patents are probably, I think they are the most powerful form of IP right. And so you can't discount them, right? So you sort of have to look at it holistically and consider all of the different rights. But really, for companies that are startups or scale ups, looking at your contracts very, very closely and seeing what rights you're giving away, thinking about how you might negotiate advantages for yourself in your agreements is really an important consideration. And I think that comes with some of that maturity that Mike and I will talk about a little bit in terms of approaching IP.
The other really important point about contracts, that's something you can address immediately, right? You can have contract language cleaned up. You can have some templates or standard agreements where you really understand in a good level of detail some of the key terms within those contracts as it relates to intellectual property, and also as it relates to likely employment, which is an overlapping and key piece, versus building a patent portfolio. Right, an individual patent may take 2 to 4 years to issue, and to create a portfolio of patents that's going to be of value to the business, that's an even longer time horizon. So you need a plan to build that out, but contracts and some of those other pieces you can act on in a much shorter time horizon. So that's another important factor to consider.
Thank you. And before we move into the next question, are you both kind of from the lenses of where you're sitting, sort of seeing, a change in the perceptions, of the organizations that you are engaging with, and sort of company sizes, that they're starting to take that into consideration, that it's not just sort of starting at the patent first, and it is really looking at this? Is there a bit of a sea change within the landscape that you're seeing?
I would definitely say there is, because I think there are so many initiatives that are out there now that are forcing organizations to think about it. I mean, if you think about digital, for example, the questions that are being asked when you're putting together a project really force those considerations. I know programs like New Ventures and Innovate BC and iPod really are forcing companies to think about all of those things, right? Not just focus on things like patents, but think about your employment agreements, think about confidentiality, think about trade secrets and all those other things. And the nice thing is that some of those programs are extending beyond just patent protection and helping develop IP strategies and offering education programs, and in some cases requiring those education programs to be precursors to being able to access some of the funding.
Yeah, I agree with that, Karima. When IEC was first getting operational in early 2021, a lot of the initial companies we talked to, when you asked them about IP strategy, the response was, well, we treat everything as a trade secret and we NDA everybody. Or we filed a provisional patent around our core innovation and we're good, right? And those conversations are changing now. They may not know the answers, but they're at least asking the right questions. And I think it's important. You mentioned there's a number of initiatives that are either giving people better information or asking them more fulsome questions around intellectual property, and it's changing and advancing the way people think about it. We've engaged with several of the government funding agencies that fund either commercial projects or research and development, even in the university or government labs. And when we first started having those conversations, the only IP question was, what's your foreground IP and what's your background IP? So we could figure out what resulted from the investment, from the funding, right? That was the only really question that those people cared about. Not about what's going to be needed for this to actually be commercially successful. What's the freedom to operate in the space? What type of position is going to need to be built? How do some of these assets or rights tie into how a business would actually be successful? So we're seeing that mindset change. We had a great conversation with a group in the federal government that's launching a new funding initiative around a particular technology, and they were very concerned about the freedom to operate in that space, and in fact had started a fairly sophisticated analysis. So that was really refreshing for me to see where things have come in a relatively short period of time.
Yeah, and I think that, and I'd build on that by saying, really, a lot of these companies are now being forced to ask. And so now we're asking, how is this IP being used towards contributing to the bottom line? Like, what kinds of licensing opportunities has this project resulted in, right? What kinds of revenue are you seeing? While we might not get those revenue figures, certainly you know that there is that impact, right? And so there is that next step forward. It's not just about what IP has been generated, but what is the benefit of that IP in a tangible sense, right? And that, I think, has changed the type of discussion and the type of considerations that companies are sort of engaged in.
Yeah, I've seen that next step. One of the more, in terms of effort put into IP strategy, again, early in the days of IC, we had a member come to us with their IP strategy document. And it was a great inventory of not just the IP rights they had registered, but of ideas and concepts they felt had potential. But they also had an inventory of their agreements, which was a great step, and some of the key terms in there. And they had a fairly detailed, almost block diagram of their technology, architecture of their technology, and had a breakdown of their different IP rights into the different components of their overall technical solution. But what they're missing, in the step we help them with, and I think is where companies are starting to go, is understanding with that technical solution, how are you actually going to compete and win with the customer? Right? Which of these technical improvements, technical innovations are compelling in the marketplace and really going to make a difference in terms of dollars and cents? We were able to find there were 8 other startups working in the same space. I asked the CEO, if you were going in to compete with customer X against one of these companies, why would you win versus them? Right? And they were able to answer that question pretty easily. Like, okay, well, which one of your IP rights protects those things? Or how are you going to build, really solidify your position around those key differentiators? And that really progressed them, I think, down a productive path. They'd already done a great set of preparatory work and were understanding the issues, but it was that next step into the business application that was hugely important for them.
Yeah, and I think it's that articulation, right? The ability to articulate how that IP distinguishes them as compared to their competitors, why their competitors can't enter into the space,
right,
because of something that might prevent them, and how they can leverage that to collaborate with others, right? So I think that those are the kinds of things that people are now talking about and thinking about, and that's sort of that next stage in the maturity framework.
Absolutely. And that then allows you to build brand, right? Because you have this sustainable differentiation, you can build a customer experience around that, start to layer in some trademarks and other things that are indicators of your brand strength, and build that out into a really more fulsome suite.
Thank you both. So kind of taking it from this thread, it's often sort of said it's very important for organizations to understand IP as they engage with service providers. So, that they're thinking about it, sort of what's best for them and not just what a provider thinks is best. And so would you both be able to share some insights on how can or should organizations, approach this for their businesses?
I think Mike and I are both lawyers, so we can say this.
I am not actually, Kieran.
Well, I am. The lawyers are experts in the law. I'm a lawyer, so I can say it.
Yeah.
And business people are experts in their business, right? And I think what quite often happens is this notion that, IP is really for the lawyers. It's not. It's really for the business people to instruct the lawyers, engage with the lawyers, get information from the lawyers in order to develop what their strategy should be, right? So And in order to do that, they sort of need to understand it. They need to be able to articulate it. They need to not feel intimidated by it. And I can tell you it is intimidating, right? It is intimidating even when you know about it, because there's so much to know. And I think if you do learn about it, it creates cost efficiency. So when you actually engage with your legal counsel, you can have that meaningful conversation, right? You can reduce the legal fees because you're not going in not knowing what you want, right? You can make informed decisions. So you can take the information that they're giving you and figure out what works for you. You can figure out how to strategically implement those assets. So the example that Mike gave, right? So they had gone through that exercise of understanding things, and clearly they probably worked with legal counsel, but they didn't think about, well, what next, right? How is it that I can leverage that for some commercial advantage, right? Risk is something that we haven't talked about yet, because of course, I lived in the land of risk, being the general counsel of BlackBerry, right? And I understood that risk, but that risk is very real as you succeed, particularly as you succeed internationally. And so you need to be able to make informed decisions about, because you can't protect yourself against every risk, but you need to understand the real risks and strategies that you can deploy, right, to mitigate some of those risks, or figure out how you're going to confront them when you actually encounter them.
So you said something in there that really triggered a piece for me, Karina, which is IP can be incredibly complex and incredibly difficult, and can be intimidating to a business leader or an entrepreneur that isn't as familiar with some of the nuance. And unfortunately, I think there are service providers that sell their services based on that, of this is hard, leave it to me, I will solve your problems for you. And I guess there's a place for that. But I really liked your take that it's on the business leader to understand the strategy and to understand the basic frameworks, because you don't want to throw this over the fence. You want to have a collaborative partner, I think, in your service provider, where you can direct, you can ask the right questions. You're not 100% reliant on them and ignorant of the choices that can put together, and don't have the tools to evaluate their recommendations, their proposals in a critical fashion. You need to know enough to make those evaluations and to instruct them properly, but you don't need to build the level of expertise that you're going to replace any of them, right? That you still, I think, need a really good suite of qualified advisors and professionals that can address the different aspects of how to secure a right in Japan tied to some material formulation, or looking at data privacy issues. If you have an AI tool that is scrubbing different sources of publicly available information, what issues are you facing in doing that, right? There's a lot of things where having that expert deep advice as you move forward with your business is really necessary. But the ability to ask the right questions and evaluate the responses in a critical fashion, I think, is incredibly important to a successful outcome there.
Yeah, and I think building on your comment, Mike, around, that breadth of expertise, right? It is that breadth of expertise where not just engaging with somebody who might talk to you about patents, but somebody who, as you're developing a tool, for example, the example that Mike gave, right, can engage with you on a discussion around privacy or data scraping or things like that, because all of those things get built into a product before it comes to market. And all of those are potential areas of risk or potential areas of opportunity, right? So can you use that data as a different commercial asset? Can you make sure that when you're entering into a different market, you're not exposing yourself to unnecessary risk because that market operates so differently from your principal markets? Like, those are really important things. And I'm not a patent agent like Mike. And so for me to be able to, I can tell you there have been instances early in my career where when I was speaking to somebody who was a patent agent, I'm thinking, well, they must know better than I do, because really I'm not an expert in this area. And so the more you equip yourself with that terminology, the more you equip yourself with that vocabulary and the ability, because having that knowledge gives you the confidence to engage in those discussions and to actually make sure that when you're talking to your legal advisor, you're not just talking about that patent application that you're filing, but they understand that there may be data implications or privacy implications or other implications that you need to articulate for them in order for them to understand that they need to engage others.
So I think that goes to what type of support do you need as an early stage company to what you may need as a more mature or larger company. Right? If you're a larger company, you likely have a team of outside support that can have specific expertise in the different team members. If you're an earlier stage company, I think you need much more of a generalist that can cover off many of those different aspects. Or if you're dealing with a specialist, at least have someone that is going to be able to find other sources of information to flesh out the rest of the ability to address some of those questions or issues that arise as a business moves forward.
Yeah, but I also think that organizations like, some of the supports that are available through ISC or the mentors that IPON or New Ventures provides really can help guide some of that discussion, right? They can be good resources that are not expensive, right? They can actually have the conversation with you around, these are the kinds of things you might want to think about. They're not a substitute for that legal advice.
Yes.
But they're a great independent vehicle to have that conversation, right? The ability to have a conversation at somebody in your shop to say, hey, this is the thing I'm building. What are some of the things I need to think about, right? I don't necessarily don't have the ability to pay a bill upfront to have this brainstorming session. So you need to come equipped, but you also need to know that there are those resources that are available. I mean, Jen, I can think about the number of times you've probably had discussions with members to say, well, did you think about that? Or did you think about that? Or let me make an introduction to somebody who might be able to have a conversation with you. And that's the beauty of being able to leverage some of what's out there already.
Thank you both. What I also hear you, both saying in all of this too, is that it's an iterative dialogue. There isn't sort of a one size fits all. So, for organizations, wherever they're starting on these conversations, that they just sort of need to sort of be armed and informed to start to have that. And it's their learning about themselves and their organizations as much as it is of the different sort of service providers that they're going to be interacting with, and to be open to that at all times, that it's not just sort of a one and done.
Not an event. It's never going to have a done check mark to it. Ongoing process where you learn and evolve as it moves forward, as is with the rest of your business.
As with the rest of your business. Now, you've both touched upon this, a little bit, where we kind of talked about, some of the resources that are, helping organizations, in developing their IP. Something I wanted to maybe talk to you a little bit more about is, for organizations don't have the wherewithal to enforce, this can often be sort of problematic. And can you sort of, maybe share some examples of, how that impacts decision making, depending on the different stages of IP maturity, and where they might be sort of assessing their maturity levels, and some of what you both have seen in your practices.
So starting with that, you mentioned enforcement. I think when you can maximize the value of a piece of intellectual property or maximize the value of IP as a whole or as a collection to a business, IP by its nature is a right to exclude others. It doesn't provide you the right to practice. It provides you the ability to keep others out or away from your innovation. And it's a right that you need to enforce on your own. No one else is going to do that for you. So there needs to be a willingness to do so at a certain point in terms of the effort that's going to have to go into that, and the resources required from the business, both in terms of people and dollars to move that forward, or really no one is going to take those rights seriously. Right? That it is easy to walk over people that do not have a track record of standing up for their rights. And then it just becomes another piece of artwork on the wall, right? We've all walked into a given technology business and seen the patent plaques on the wall. Right? If it's just another decoration, that doesn't really advance or drive value into the business. There needs to be a willingness to deploy those, and that takes some corporate willpower and some corporate resources to do so, and really digging into some key understandings of what is involved in really being successful in that outcome around really in my work over the years, being able to clearly demonstrate the power of three things: the validity of the rights that you hold, the infringement of those rights by another party, and the current or future revenue tied to that infringement. Because at the end of the day, this is about creating business leverage, and that leverage comes from your ability to place a royalty on that revenue or to stop that revenue altogether through an injunction or other means. So thinking that process through and understanding kind of leverage points within that process requires a business to have evolved to a certain level of maturity from just starting its process of registering and collecting rights, which most early stage organizations are focused on.
Yeah, and I think, enforcement is I call it a process of not just requiring dollars, but a lot of intestinal fortitude. It is difficult and a challenging process. Fortunately, and it is it is resource draining in so many ways, not just dollars, but the distraction, right? The distraction for a company. And sometimes, we'll talk about it a little more on the flip side when you're on the receiving end versus on the assertion end, right? It does come with risks. It comes with risks around whether or not customers, you're going to get countersued, whether you're going to have the financial ability to actually see that lawsuit through. Fortunately, there are certain things that you can do. There are other types. For trademarks, you can use border enforcement proceedings and things like that. And sometimes those are quite effective, right? But fortunately, there's also resources like Mike. I think one of the reasons why IC was founded was to create these patent pools. And I'm sure you can talk about those far more effectively than I can. But being able to rely on some of those resources, the ability to access IP insurance. And yes, it's expensive, but I think there are programs like IACs that help companies. And so maybe Mike, I'll let you talk about those, but it takes a lot of time, a lot of energy, and some courage because you're out there.
Absolutely. That courage piece is important, but you need both the right set of IP rights to enforce and, as you said, the financial wherewithal to work your way through that process, because it is, in most cases, not a inexpensive undertaking. Although, as you said, there's the ITC, other border enforcement places in different countries that can provide some different paths at different price points. So it's how do you fund that? How do you get the right collection of assets? From day one at IC, as I mentioned, we've been building our patent portfolio to help Canadian companies answer that question of, if I don't have the right patent or set of patents to address the situation, can I speed that process up? Obviously, individual companies can go out and buy patents on the open market, and that's a tool and a mechanism available to them. But if we have already done the research, identified patents that have leverage against key players in the marketplace, right, it really speeds up that process. And also, because we're buying on a consistent basis, I think we're able to get patents at a lower price point than someone that has a really urgent situation and needs to get patents fast. So the financial piece can be impacted by that as well. As we were talking to member companies about that tool, though, many of them came back with the question of, that's great, that will be a huge help, but how do I afford to pay for this? We don't have enough capital to fund that on our own. And then they asked, we didn't, as IEC, didn't want to become a litigation funder. So the solution we came to that problem was to identify an insurance product. So Aon, the insurance broker, helped us establish a baseline program for our membership. So we offer all of our full members $1 million of defensive IP coverage, and $500,000 of that coverage can be deployed if they need to assert their own rights as well. So that comes with their membership with IAC, and companies have the ability to supplement or increase the coverage amounts at their own expense. The two huge wins there, the insurance providers have told us they're providing at a minimum a 35% discount to what companies would achieve if they sought that insurance on their own. because they can diversify the risk across our collective of companies. And our membership is over 250 companies as a whole, and I think 85 full members. So there's a good number of companies there participating. As well, we had several of those companies say they got turned down for insurance when they applied on their own, but were able to actually achieve that coverage individually. We also had a member who had their own insurance coming into IAC, but that coverage only covered infringement that happened in North America. And they actually faced a lawsuit in Europe, and their insurance package was not going to fund that. And the IAC packages almost worldwide. There's some nations like North Korea, Cuba, etc., that aren't covered, but it provides a very broad geographic footprint. So that's an important tool for our members.
Wonderful. Thank you both. Now diving into sort of a little bit of a discussion around how companies go about understanding what they know and what they don't know about IP. And I know you both have touched upon some of these areas earlier on, so would love to hear your thoughts on this.
I think a lot of organizations, I know certainly IPON and I know IAC, and I believe New Ventures are exploring implementing what are called IP maturity tools, right? To help companies assess where you're at. So, coming in and knowing where you need to pay, where you're at when you come in through a program, understanding as you go through a program where you're at a little later. It allows, I think, companies to identify where they need to pay attention, right? So, I mean, these are these frameworks that are being developed. And, I think they help to identify some of the strengths and weaknesses of your particular scenario, right? Of where you're at and trying to help you figure out where you need to pay attention. I'm sure Mike I know IAC has developed a pretty comprehensive one, so he's probably better equipped to talk about it.
Yeah, we have an IP maturity framework that we use with our membership. And you mentioned IPON and New Ventures BC. We're actually in conversations with both of them about how they can utilize that tool, as well as how we can utilize some of the frameworks that they've built in their operations over the last year or two. As you said, it really allows us to assess where the organization is in their maturity, right? We see very different sets of knowledge and experience with the range of companies we deal with. Some are first-time entrepreneurs coming from a very technical background and haven't had very limited or almost no exposure to intellectual property. Others are more mature businesses. They may have an in-house patent agent or IP attorney, or at least a defined IP lead, and have been through some of these issues over the last number of years. So it's really important that we don't treat both of those companies the same. They need different resources. They need different education and training material. They need very different support. So our tool really looks at 4 different aspects of intellectual property. It evaluates IP strategy. What is the strategic thinking of the organization when it comes to building their own intellectual property and how the business is going to compete? It looks at the risk profile of the company. So what is both the risk of internal loss of IP based on their practices? What are the external threats, IP threats that business may face? And what are the mechanisms the company already has in place to evaluate that and mitigate those risks? The third piece we look at is data. And Karima, you mentioned data earlier. More and more value, business value is being derived from data in today's economy. My personal experience, our business at Tech Insights I was part of, data is what drove a massive increase in corporate valuation and enterprise value. So we place a lot of emphasis on the thinking around data governance and the business models that organizations are building around data. And then the final piece is IP culture. What people, processes, practices do they have within the organization? What is the consistency and emphasis put on those practices? How do they reward people that are performing well within those frameworks? That culture piece, I think, is hugely important. You'll notice in those 4 categories, I didn't mention any specific IP rights. We think that that comes out of strategy, that comes out of the risk evaluation, those evaluations of the individual rights, but we're really looking more at the framework level of, are they putting the right pieces in place to allow the building of the rights and the dealing of the risk that comes from other rights at the right level. And really it's about, can we then take a company from point A and start to step them forward in the level of sophistication and practice to the point where intellectual property is fully integrated in how the business operates. And that's the end goal of where I think we all want to take Canadian businesses. And we're doing that at each stage in the framework, where they're evaluated at level 1, 2, 3, 4. What are the next steps or the missing pieces that they have, and really providing pathways to take them to that next level. That's really, really important to us. The other piece with this is it allows us to track progress over time without having a key evaluation framework. You have no ability to say, yes, company X is actually making progress, because there's no metrics to track and evaluate that progress beyond basic patent counts or trademark counts, right? Counting stats don't tell the whole picture. So you need some other tools to evaluate, are these entrepreneurs learning and doing the right things so that they're going to be more successful at the end of the day? And we end up with companies that are driving economic prosperity into Canada.
Thank you. I'm wondering if we might be able to sort of to flesh out a little bit more specifically on the sort of the strategic side. I know FTO definitely sort of comes up as one of the areas of importance. And if you both could share a little bit more around that for an organization, and maybe Mike, if you might be able to also discuss a little bit of how the patent pool sort of works for a collective as also one of these sort of strategic pieces as well.
Absolutely. So we view good IP strategy as having 3 primary inputs or piece of information that need to be evaluated. And unfortunately, I think in many cases, only one of them really is, and that's the technology roadmap. So people quite frequently drive their entire IP strategy about where the technical innovation is happening, and really have a roadmap to capture and build a position around that. That's an important input, but there's 2 pieces that are missed as part of that evaluation. What is the competitive environment the business is operating in, and how is that business going to win in that environment? So who are the other companies that are playing? What products are they offering? They're competing with yours. What are the advantages your company's products have against theirs, and how do customers react within that interplay? That information is really, really important. That's the intersection of IP strategy with business strategy, is that understanding. The other piece that needs to be incorporated into it is the IP landscape. So what are the IP rights that are relevant to the products or technologies you're delivering to the market? Who holds those technologies? And what sorry, just blanked for a second. Apologize, somebody just rang my doorbell and distracted me. How do those people use those pieces of intellectual property within the business? Do you have a situation where you're going to be introducing a new technology in the wireless telecom space, and you're going to have to deal with Nokia and Ericsson and those type of companies with a track record of aggressively enforcing their IP rights? Or are you in a smaller space that's less active with less aggressive companies? Understanding that lay of the land and how you're going to intersect with that is really important as you build a strategy. And that strategy should establish both a roadmap or a plan of how you're going to build your IP rights that create your ownership position around the technologies you're developing, and also how you assess the risk in that landscape, and what are the specific mechanisms you need to put in place to help mitigate those risks.
Yeah, and I think the piece that I would build on in respect of that is the defensive piece, right? It's not just about building out where your IP can be protected. It's also anticipating where somebody may come next and figuring out how you can defend yourself. I mean, I think back to my early days at BlackBerry, or RIM as it was then known. Really, the idea behind building out this very extensive patent portfolio was not around assertion. It was really around building out a strong defensive posture, right? The thinking back then was, okay, well, you know what? We're probably never going to have Nokia's portfolio or Motorola's portfolio, but we do have the ability to say, well, you know what? We have these patents. And if you think about the fact that you have 10 times more sales than we do, it's going to be more painful for you than it is for us when you turn around and sue us. And so let's figure out how we can, and it may not be something that related to BlackBerry's products at the time. It was something that might have been where their competitor was going, right? So it's sort of looking at that landscape more holistically and seeing where your competitors are going, understanding that landscape, right? Understanding not only how you can have freedom to operate vis-a-vis where you are, but looking at where your competitors are going and trying to map out your IP rights in a way that you can use them more defensively rather than just offensively. And sometimes I think that's more valuable, right? Because you may not be in a position where you can assert, but you can certainly be in a position to say, do you really want to do this?
Very much so, that deterrent effect. And I love the fact you mentioned the revenue ratio, right, or size of the business. I had an ex-colleague that used to refer to asymmetrical patent assertion, right? And it's all about, can you create an imbalance in terms of the revenue exposure and the number of patents that read onto those revenues, or number of forms of other IP rights that read onto those revenue streams, so that the equation gets imbalanced in your favor. And then you're in a position, whether it's either an offensive or defensive position, to achieve the outcomes that favor your business.
Yeah, and that comes with being mature, right? That comes with understanding, right? Comes with, I mean, I think another strategy that I think is really important is when you are that small player, proactively thinking about going out and knocking on somebody's door and saying, hey, you know what, can I get a paid up license? And they might say, well, you're not going to survive, so I'll give you a license. I'll give you a paid up license. And you might end up being in a far better position than them coming and knocking on your door 3 years, 3 years from now when your revenue has really grown, right, or your sales have really grown, right? But that is part of understanding that landscape, understanding your own business, right? Because no legal advisor is going to have that conversation with you to say, did you think about this? But before you go and approach that company, you should have the discussion with your legal advisor so that you understand what risk you might be exposing yourself to. But it is, those are all part of getting more mature, understanding where your company's at, where your company's going, and then being able to develop a strategy that is unique to you, which ties into your business and really allows you to leverage the expertise that you're going to need.
That's that concept of taking a proactive license is an interesting one, and obviously you need to be a bit selective with deploying that tool. We had that. That's part of our portfolio. We were doing a patent buy with a large multinational and had the opportunity to sign a covenant not to sue with them with respect to all of their lithium-ion battery patents, and the ability to pass that on to our members that were using that technology in some of their products. So, and we got a quite attractive price point for that deal, again, because we were doing it at the front end rather than forcing them to come and enforce their rights and spend the money to do so. And that's been a really attractive deal for several of our members. So I like that thinking as companies start to move forward.
Wonderful. We've got a couple of questions that are coming in, and I know one that sort of relates to what I was going to ask as well, is when you both sort of say what are some of the best practices that organizations should implement as it relates to IP management, and a question that's just come in as well is you talking also around IP culture for a company. If you could elaborate on this a little bit more.
Sure. I mean, I think I can start. Really, I mean, I had the good fortune of having been at RIM and now known as BlackBerry. And really, that was such a big part of its success was that IP rich culture, right? It was rewarding people. It was recognizing people that had filed patents, asking people to send in ideas. And so I think we had an ideas@rim.com email address, which was really company people, like anybody in the company saying, this would be a great innovation for our product. And everybody got something. They got $50 for just submitting an idea. And then people that actually were successful in getting a patent awarded would be honored at a banquet, and there would be a big deal around it, right? And there would be monetary consideration. So it really created that culture. And it wasn't just around patents. It was also this serious culture around enforcement, right? When somebody didn't want to sign off on an annual acknowledgement around, protecting trade secrets or confidential information, it was actually an actionable thing. It was actually, people that were in senior management that got involved in making sure that people understood that these were things that they needed to comply with, because employees actually are one of your biggest assets in terms of helping build out your portfolio, but they also create some significant risks when it comes to protecting your assets. So that culture becomes incredibly important as you look at IP, both from a benefits perspective as well as from a risks perspective.
I sat once in an IP seminar where this question was asked and was very frustrated with the response, because it talked about the three individuals involved really viewed culture building as the soft stuff, right? Like taking your staff out for drinks every Friday, or building this culture of more the raw aspect of culture. And to me, culture is, how do you consistently make decisions? How do you consistently behave in the organization? And how do you build high-performing behaviors, high-performing activities, so that is what is expected, and that's what the group migrates to, and that's how the group makes their decisions. And that comes down to having clarity on what you're trying to achieve, how you want to achieve it, right? And giving people feedback about that, rewarding them when they do it well, giving them critical feedback when they're not. But here you mentioned like having financial reward structures for participation and outcomes. I think that's key to building it, right? That's going to build momentum as you practice that more. But it comes down to that really consistency of the leadership team, obviously thinking about this as being an active part of the example they're setting, but building the set of practices and reinforcements into the organization, so it becomes how everyone thinks and operates within the business. That's really how I think of culture. And if you then take that into what are the best practices that you would look to as an organization, I think it starts with leadership, having an individual or maybe multiple individuals on the leadership team responsible for IP, having someone on the operational side that's the obvious lead in that perspective, right? As the business matures, that's going to become a formal structure or a formal team in most companies. But for an early stage company, oftentimes that's one person that is passionate about it, understands it, and is willing to spend a chunk of their time really building these things out. And that's going to come down to that individual or individuals setting clear strategy, communicating that strategy consistently across the organization, building the people and process steps that they need to implement that strategy, showing people that you're going to pursue IP rights, that you're going to evaluate IP risk on a consistent basis. To me, those are the best practices, particularly from an early stage standpoint. Right, as the organization grows and matures, there's some other things I would layer in there, but I think the points I really want to emphasize, so I think those are where to really get started and have success.
Yeah, and I think, I can't emphasize enough that senior leadership engagement, right? Setting that example, setting the right tone, making sure that it is something that is not just something that's pushed down, but it's throughout the organization, and it applies to everybody.
Thank you both. A couple additional questions that have come in. One is around, many startups are spinning up and solving problems, that are common and specific sort of with AI. And, and the thought is many of them are likely to be subsumed by, the likes of Google, Microsoft, AWS, and others. Can startups protect themselves? And if so, how?
Yes.
Well, go ahead, Mike.
Yes, they can. There's always startups are at a disadvantage with those larger companies. They have access to more people. They have access to very experienced people. They have financial resources that likely dwarf those of a startup. But I think the IP realm, it's very similar. You're competing. The same goes to your product development and your technology development and your sales effort. Right? They have bigger sales teams. They have established product lines. They have marketing budgets. So you're always competing in a David and versus Goliath scenario there. But I think the same techniques that go into those other areas work in the IP realm of you need to stay focused, right? You need to really have a clear North Star of what you're trying to achieve. And you need to be ruthless in your decision making of what you're going to do and what you're not going to do. But if you make good decisions through that process, I think you can definitely be successful and build out an IP position that not only adds value to our organization, but is like a real difference maker in terms of the growth prospects of the organization.
I also think that startups have that advantage of being somewhat more nimble, right? Not being confined by being in a large organization and being stifled in some respects. And they also have the ability to create a culture where people want to do the right thing, right? People want to be engaged. People want to be working those extra hours to do the right thing, actually have those unique ideas. It's not just about a paycheck. It really is about making a difference. It's really about building something unique, right? A lot of that mindset that you have in that startup culture. And Mike and I both, I think, been in organizations which were startups and scale-ups and large organizations. And there is a difference in the culture. And sometimes that difference in the culture can really help these companies to become successful and be able to compete on a different footing.
And
I'll
if we
just
look
provide one sort of follow-up reference on that point. There's a thought leader on this topic that I pay close attention to. Her name's Jackie Hutter. She's based in the Atlanta area, I believe, definitely in Georgia. But she does a lot of writing, a lot of YouTube videos talking about startup IP strategy and how to stay focused, start small, and build the IP that's right for your business and to really validate your customer journey and validate your IP growth kind of in parallel with each other and really tight cohesion. And not to get caught up in the large corporation, large law firm approach to dealing with IP. So if people are part of early stage businesses and looking for some content that's out there, recommend some of her thinking is, I think, quite productive.
Thank you. And you both have touched upon this a little bit as related sort of to AI. Are you seeing changes emerging sort of for IP strategy management sort of with that drive, apart from, say, simply treating data and models as a trade secret? Is that something that's coming into your radars?
Trade secrets need to be a key part of IP with respect to AI. But it's a frustration of mine in recent months of far too many people thinking there are challenges or limitations to pursuing patent protection around AI. If you look at the volume of patent filings internationally, they have scaled unbelievably. Like the number of patents being filed by international companies around AI is astronomical. And if Canadian companies are serious about competing against those type of companies, they need to understand that that's happening and have strategy in place to deal with it. I don't think trade secrets are going to be enough in that environment.
I would agree with Mike. I mean, I think it is a common misconception that patents aren't available, and really, I think engaging with the right advisors, and we have a number in Canada of advisors that are really very sophisticated in this area. And so that would be a really important consideration. But again, the layering is important as well.
Wonderful. Thank you both. And just as we are, at time and before we close this off, I will mention that we will send out, some of these resources and links. And before we send off for a closeout, is there one key takeaway? What is the one key takeaway you'd love to leave the audience with today? Karima, I'll go with you first.
Just being engaged, right? Being engaged on this, just like you are in your business strategy, right? Not treating it as something that is within the realm of some other expert. It is within the realm of your expertise if you are the business leader, because you really do need to get familiar with it. And while you might not be an expert, you can certainly be highly proficient, and that will carry you very far in this.
Have a North Star that keeps you focused, particularly if you're an early stage company, and have that North Star be an understanding of what are you winning on when it comes to selling product, selling your business, right? What are the features that are key to your success there? And that is what needs to guide your IP development going forward, is that understanding of how you're going to win.
Thank you both so much for carving out time out of your very full schedules to come and talk with us and our audience today and sharing your insights. On behalf of Digital, I say thank you, merci, and I hand it off to Zane to close us out.
Thanks, Jen.
Thanks, Jen. Really appreciate it. Thanks, Karina.
Thank you.
Thank you once again for joining the webinar today, hosted by Digital and our wonderful Director of IP, Jane. All those attending today will receive a follow-up email in the next couple of days with any resources discussed throughout the session, including the webinar recording. That is it from us at Digital, and see you at the next webinar session. Goodbye.
Thank you. Bye.
Thank you.